Hello students, I am Dr. Vibha Rathore, Assistant Professor, BSSS College, Department of Humanities. Today's topic is MRTP Act 1969. And the best part about this act is this was the first law that regulated free and unbound trade in India. So today we are going to discuss about this topic, and the sole purpose which is very important about this act, this I am going to tell you, this is the achieving the highest possible production with least damage to people at large while securing maximum benefit. Before starting this act, I just want to tell you that why this act was shaped and sanctioned in 1969. What is the importance of this MRTP Act? So there were 3 committees which were formed to study for this act. Number 1 committee was Hazari Committee. It was based on the Hazari Committee report on industrial licensing procedure in 1955. The second was Mahalanobis Committee report on distribution and levels of income, which was formed in 1964. Third was Monopolies Inquiry Commission report of Das Gupta that was formed in 1965. So the Government of India enacted Monopolies and Restrictive Trade Practices of 1969 with an objective of preventing the concentration of economic power to the common detriment of the public, for the control of monopolies and prohibition of monopolistic restrictive trade practices. Today in this module, I am going to discuss about MRTP Act and its role as the competition regulator of India. Simultaneously, I will talk about the impact of industrial policies in framing of MRTP Act and the amendments made for this act. Let's talk about the origin of MRTP, how it's originated. The MRTP is an important but a very controversial piece of economic legislation. It was passed by Parliament on 18th December 1969. The Act came into force from 1st June 1970. But changed trade policy of the nation and inflow of foreign investors into the economy, it was felt that MRTP Act law had become obsolete and lost its sustainability. Therefore, a paradigm shift was made from curbing monopolies to preventing the misuse of dominance of power, and MRTP Act has been amended in 1974, 1980, 1982, 1984 and then in 1991. What is the current status of MRTP? Let's talk about this. MRTP Act is repealed and was replaced by Competition Act 2002 with effect from September 1, 2009. The MRTP Commission was replaced by the Competition Commission of India. Now the question arises, why we are studying this act? We are studying this act because it is the base of the competition law, and it is important to understand competition law. That is why we have to understand this act, this MRTP Act in depth. What are the aims and objectives of MRTP Act? MRTP Act deals and regulates trade practices. There must be a trade practice in relation to the goods and services. The primary concern of the Act is disciplining and regulation of trade practices are market forces and behavior, so that there is no concentration of economic power to prohibit all attempts to stifle competition and to protect consumers from being exposed to unfair trade practices. Initially, there were 3 objectives of this Act. Number 1 is to control monopoly and monopolistic trade practices. Second one is prevention of concentration of economic power in few hands, and the third one is to regulate restrictive trade practices. This act has 3 areas of regulatory provisions. Number 1 is concentration of economic power, number 2 is competition law, and number 3 is consumer protection, and all 3 areas are very important for this MRTP Act. Let's talk about the salient features of MRTP Act. The first feature is command and control approach. What is this command and control approach? The Act made it mandatory for enterprises having assets exceeding rupees 20 crores to take having assets exceeding approval of the central government before any kind of corporate restructuring or takeover. The criterion for identifying the dominant undertakings was also fixed. Second is monopolistic trade practices. The monopolistic trade practice is a result of few things. One is unreasonable pricing. Second one is limiting or restricting competition or no free market. Third one is limiting development. Fourth one is making unreasonable profits. Section 2I of the MRTP Act 1969 defines monopolistic trade practice as a trade practice that have the effect of preventing or lessening competition in the production, supply for distribution of any goods or in supply of any services by misusing one's power to use the market conditions in terms of production and sales of goods and services and thus abuse its market position are called monopolistic trade practices. Third feature is restrictive trade practices. The restrictive trade practice is a result of refusal of deal with the consumer's selective dealings, discrimination in pricing scheme, restriction of area, and then tying up the sales. Activities that firms indulge in that tend to block the flow of capital into production in order to maximize their own profits and to gain control over the market. Such activities are termed as restrictive trade practices. Such firms also control conditions of delivery to affect the flow of supplies, leading to unjustified cost of production and distribution while establishing their monopoly in the market. Third feature is unfair trade practice. Section 36A of MRTP Act 1969, which was inserted on the recommendation of Suture Committee report, laid down as to what may be termed as unfair trade practices. One is false representation and misleading advertisement. Second one is misleading representation regarding utility, quality and standard of goods and services. False guarantee or warranty. False claims or representation regarding price. False facts regarding sponsorship and affiliation, etc. Free gift offer and price schemes. Let's take one illustrative case of Shyam Gas Company. This was a case where the supply of cooking gas cylinders was in short supply, which led to unfair exploitation of the situation. Shyam Gas Company was the sole distributor of BPCL for cooking gas cylinder at Hathras, UP, which was allegedly engaging in following restrictive practices. Giving gas connections to the customer only when he purchased the gas stove or hot plate from the company, charging customers twice the price for supply or fitting and appliances. The MRTP Commission held that company was indulging in a restrictive trade practices that was prejudicial to the interest of the consumer. Let's talk about some shortcomings of MRTP. The market conditions turned out to be hostile for the consumer, and small business and as well as big businesses alike were subject to excessive control. The provision, though aimed at benefiting the consumers and the industrial growth, often played out tough and stringent provisions did not benefit anyone. Tata Docomo, a mobile service provider that rolled out only 2-3 years back in the Indian market, entered at a time when there were established players in the market like Airtel, Reliance and other state-run BSNL like that. But Docomo, with the pricing policy which was unlike the prevailing market conditions, offered calling rates which changed the pulse of the market. The market prior to the arrival of Docomo was based on per minute charges, but Docomo came up with the per second policy, thus forcing other established players to also offer similar rates. Though such strategy was predatory in nature, but it helped in establishing a more competitive market which only went to help the customers. Thus, such predatory pricing is not necessarily anti-competitive but rather an agent to bring about better options for the consumers. Hence, this is more beneficial in terms of consumers' welfare. However, the MRTP Commission took up a strong case against such pricing, and though it aimed at benefiting the market by ensuring fair competition, it instead closed down to benefits to the customers. Hence, what was then required is a strong case-by-case basis of handling and not absolute ban on predatory pricing. MRTP Act, a damaged legislation in need of repair. So, there were some phases came, and these phases are known as the amendment phases. So, amendment phases time period I have taken that 1981 to 1991. The phase of 1981 to 85 shows a positive growth in contrast to preceding decade, primarily because of the 1984 reforms. This broadened investments across the public and private sectors, while some level of deregulation was allowed. Most importantly, the cap on MRTP firms was increased, which resulted in the more number of small sized firms to be free from government regulation. Thus, in turn, leading to an increase in the production of consumer goods, especially durables. Thus, the loosening of government hold on small businesses was returning dividends to the consumers. What was that 1984 amendment? The MRTP Act 1984 omitted the definition of monopolistic undertaking under section 2J and made necessary changes in section 31 of the Act. This amendment was based on the recommendations of such a committee. The amendment inserted in section 36A to the Act to protect the final consumers against the unfair trade practices so that an effective action can be taken against them. Thus, claims against false advertisements, deceptive representatives of goods, false guarantees came under the purview of the Act. 1991 amendment, what was that? This amendment allowed the MRTP Act to extend it to the public sector and the government owned companies also. After this amendment, the private players functioning in market were no longer required to take special permissions or special approvals from the government before carrying out any corporate reconstruction. This amendment to the MRTP Act to effect in the light of new economic policy, which led to the opening of Indian economy. So, the license Raj, which restricted the growth of the Indian economy, was abolished. New Act, that is known as Competition Act 2002. When problems arose in the functioning of MRTP Act 1969, there arose a need of new revised competition law policy. However, the question that arose was that whether we need to amend the MRTP Act or there was a need to create an altogether a new legislation. For this purpose, a committee was set up headed by S.V.S. Raghavan. Competition Law 2002 was announced by the then Finance Minister of India in his budgetary speech of 1999. The new law covers all the major loopholes that were present in the old MRTP Act. The Competition Act 2002 primarily deals with these three important aspects. One is anti-competition agreements. Second one is abuse of dominance. Third one is combination regulations. One more is there that we can call competition advocacy. So, in that way, this MRTP Act was repealed and replaced by competition law. Now, I am summarizing my entire topic. Competition law and policy in India is emerging as a means to enhance economic development and competition as well as protection of consumers in India. The Competition Act 2002 was put together with the intent to address the shortcomings in the MRTP Act of 1969 in the light of the changed economic circumstances in the country. Different decisions from the Competition Commission and the courts have considerably changed the jurisprudence of this subject within a very short span of time, and it is important for the students constantly monitor the cases coming up in this area. Now, I am closing this topic. Next, module we will discuss about some another act and we will meet soon. Thank you very much.